Hearsay exceptions continued. Hearsay statements are admissible if they concern a declarant's state of mind, emotion, sensation, or physical condition existing at the time the statement was made. Statement of then existing state of mind, usually offered to show a declarant's intent at the time the statement was made, or has circumstantial inference that declarant's intent was likely carried out. Distinguished from statements offered as circumstantial evidence of declarant's state of mind, which are not hearsay. Statements of intent may be admissible as circumstantial evidence, tending to show that an act was committed at a later time. Statement of then existing condition, usually offered to establish some physical condition, symptom, or sensation that declarant experienced at the time of the statement. Items to note: statement must concern a then existing condition or mental state. Statements of memory or belief are inadmissible because they do not reflect on the then existing condition. Statement of physical condition for diagnosis or treatment. Statements regarding physical condition are admissible if made to medical personnel for the purpose of diagnosing or treatment. Requirement is 1. Statement must be made to medical personnel. Medical personnel includes anyone involved in treatment or diagnosis, not necessarily a doctor. Or 2, statements must be pertinent to assessing in the diagnosis or treatment of a condition. So this is related symptoms such as an admission about an injury-causing event that are inadmissible. So an example is the statement by a declarant to an emergency room doctor that she was shot will be admissible, but the identity of the shooter will not, as it is not pertinent to treatment. Distinguish from statements of then existing physical condition. Statements concerning then existing physical condition are admissible regardless of whether they are made to a medical personnel. Then existing has to be contemporaneous. Business records. Requirements. Hearsay statements in the form of business records are admissible if they, 1, are a record or transaction recorded by a business or organization, such as receipts, reports, or patient records. 2, made in the regular course of business, such as regular practice. 3, made by someone with knowledge at or near the time of matters described. Or 4, authenticated or certified in writing. So there's trustworthiness. A court may exclude an otherwise qualifying record if circumstances indicate a lack of trustworthiness. Absence of record. Records meeting those requirements may be admitted to show that the matter did not occur or exist. Police reports. In criminal cases, police reports or other criminal investigative reports are inadmissible against the defendant as business records or public records. Multiple hearsay issues. Business records often involve multiple layers of hearsay. Every layer must fall in some exception or exemption to be admissible. For example, minutes of a business meeting with a secretary's notes of participant statements. Secretary notes are one level of hearsay. Participant statements are another. Public record. A public office or agency record is admissible if 1, it describes the activities of a public office or agency. 2, describes either the matter observed pursuant to a duty imposed by law, or B, factual findings resulting from investigation made pursuant to the authority granted by law. 3 is made by a public employee within the scope of their duty, and 4 is made at or near the time of the event. So an exception is in criminal cases, police records or other criminal investigative reports are inadmissible. Trustworthiness is required. So courts may exclude an otherwise qualifying public record if the source of information or other circumstances indicate a lack of trustworthiness. Absence of public record. Certification of testimony from a public official that a diligent search failed to find a record is admissible to A, prove that the record does not exist, or B, prove that the matter did not occur if records were kept regularly. Judgments and prior convictions. Judgments. Certified copies are admissible in both civil and criminal cases to prove any fact essential to the judgment. Prior convictions are inadmissible in criminal cases against non-doctors unless used for impeachment. Miscellaneous hearsay exceptions are the learned treatises which arise with expert testimony. Only learned treatises are accepted authorities in a given field. This is established as reliable and acceptable authority by testimony, admissions, or judicial notice. Experts can rely on learned treatises on direct exam or can be impeached with information from treatises on cross-exam. If admissible, statements from learned treatises may only be read into evidence. Family records. Statements of facts found in family keepsakes such as jewelry engravings or genealogies. Ancient documents, a form of documentary evidence. Confrontation clause, an otherwise admissible out-of-court statement offered against defendant in a criminal case may be excluded under the Sixth Amendment Confrontation Clause. Out-of-court statement offered against defendant will be excluded if 1, the declarant is currently unavailable, 2, defendant had no prior opportunity to cross-examine the declarant about the statement at the time it was made, and 3, the statement is testimonial. An exception is an out-of-court statement will be excluded if declarant is unavailable as a result of defendant's own wrongdoing. Testimonial statements includes prior statements made during court proceedings, statements made in furtherance of a police investigation. An example is a statement aimed at producing evidence potentially relevant to a later prosecution. Business records are not generally considered testimonial. Exceptions are statements made to the police during an ongoing emergency, are non-testimonial, and can be admitted without violating the confrontational clause. The confrontation clause bars admission of out-of-court statements by a non-testifying co-defendant if a statement expressly implicates another defendant. An exception is that a co-defendant's out-of-court statement is admissible if either declarant co-defendant testifies. So confrontation clause does not bar an out-of-court statement if the declarant co-defendant testifies and is subject to cross-exam. B, redaction. Portions of the co-defendant's testimony referring to the non-declarant's defendant are redacted. Redaction is not effective unless it clearly makes the non-declarant co-defendant identity anonymous. C, coerced confession. The statement is used to rebut a charge of a coerced confession.